Judge Scieszinski, we welcome you here this afternoon, and we anticipate hearing your opening statement.
Thank you. It's a real pleasure to appear in front of the entire group today. I've had such a nice time traveling our state and visiting personally with many of you, and I've been so proud of the system and how it's worked because I recognized your questions for me to be balanced and to show great insight about the needs and the future of our court system. And I guess for the larger audience that we have with us today through the streaming live video, it's very reassuring that none of those questions indicated any kind of agenda or any kind of litmus test, and all of it was testament to the fair and impartial way that the merit selection process is supposed to work. So I commend you on that, and I thank you for the selfless service you're committing with all the hours and all of the energy that it takes to implement this system. I'd like to share some ideas with you today about my vision for the judicial branch and some specific ideas that I have, and I really look forward to your questions when I'm finished with that. I come to you as a citizen judge to help address the unprecedented challenges that our judicial branch faces right now. We need to restore confidence in our court system. We need to rebuild after crippling budget cuts. And we need to bridge into a delivery system that is modern and efficient. My motivation for seeking appointment to the Supreme Court is one of civic purpose. I really like my work on the trial court, as I've told many of you, and the thing that makes it the most special is that we get to work daily with people. But I think I can make a difference on the Supreme Court right now, and so that's what motivates me to be here today. Aside from the sheer courage it takes to try in this political environment, my 15 years of experience as a busy lawyer in a county seat community, and then followed by nearly 15 years now as a trial judge on a circuit of 10 counties, equips me with some real skills. You know, I have very broad experience in the law, an appropriate attitude about public service and what that requires from me. I have tested judicial temperament, proven legal judgment and writing ability, and strength under fire. I think our court now needs more than ever before in our history seasoned jurists who know firsthand the multifaceted demands of delivering justice to real people in real places and under real circumstances, and also folks who can work in a high-profile role to restore the trust of our staff, our trial bench, our greater legal community, and all Iowans. I'm just one of those experienced jurists who's stepped forward for your consideration. Well, the first point I'd like to share with you is my concern for us taking up the charge to revitalize public support for the courts. The Supreme Court has had a very effective public education program, and it's made remarkable strides over the last several years, but we really must do more to shore up public confidence and trust in the work of justice. The court should, as a next step, nurture a new, a better branch-wide work style, one that focuses on customer relations and community outreach. And in saying that, you know, none of us needs one more thing in our job description to do because we have plenty on our plate. But I think this involves the kind of work that would enhance what we do already. Would require us to think about what we do and do it in a different way that yields more public service, a greater incorporation of transparency, and will transform public understanding about the work of the courts. Judges are public officials, and we all must seek greater insight into what that means, and we need to act on that, and the Supreme Court should be leading the way on that. Access to justice issues across the board need to be given priority so that all of our litigants, our customers, benefit from a court experience that comes at a reasonable cost, is timely, and is user-friendly. Our Supreme Court has underway a civil justice reform study, and that's an important first step. But more must be done for our other crowded dockets. Second point I'd like to share with you is that our judicial system must be accurately defined and it must be defended. The Supreme Court has a responsibility to communicate clearly and often about the role of the courts in our state. And part of that message needs to be that the work we do is constitutionally empowered and it's constitutionally required. An important part of that message needs to be that the courts protect the rule of law and the rule of law protects the people. And there must be an assertive response to political attack so as to defend the people's court system. A press invitation for comment must never go unanswered. Rather, it should be seen as an opportunity to help the people, our customers, our constituents, understand the principles of judicial service and appreciate the leadership within the judicial branch. For example, when court integrity is impugned, somebody must step up and speak the constitutional truth. It would reassure our public for a judge to be the person that steps up and says something like, I took an oath to support the federal and state constitutions and to administer justice fairly to everybody, without fear, without favor, without any expectation of reward. And I do that in each and every case. I've done it in the past, I do it today, I'm going to do it in the future. I'm going to honor that oath of office no matter the political or other pressure that confronts me. The people need to hear that from real live jurists. And the final point I'd like to make is that the Supreme Court must restore its connections necessary for us to do our work well. Black robes and a constitutional birth are simply not enough to win solid public confidence for our Iowa court system. We in the branch have to earn that daily. Supreme Court justices set the tone, and they must embark upon an effort to humanize the judiciary and to portray a servant leadership that inspires deep trust and an honest respect. In addition to a revived civic connection with the people, the court should strive to lead by example and spark a synergy with our branch employees. For example, one of the things that could be done is for us to come to grips with some of the delays that cause some appellate outcomes to lose their full measure of justice. The court can take a bold step by making itself subject to timeliness rules like other judges and staff members in our system. And it can't go without saying that we have to invest in healthy working relationships with our fellow branches of government, the executive branch and the legislative. It's crucial that we make the case for fair funding for this branch of government that is inundated with the work of our essential purpose. Unlike other government programs that might be seen as optional, our core functions are impaired, are crippled right now due to a denial of resources, and we just have to make that case. And it's going to require a lot more work with our other branches than doing all the necessary steps at budget time. So in sum, we need to walk the walk as government leaders in our judicial branch. Now, it might sound like I have all the answers, but I know I don't have all the answers. I've got lots of ideas, and I have a lot of enthusiasm and a desire to work for the betterment of our branch and the people we serve. And I'd be happy to take your questions about my ideas or about my materials or anything else that strikes your fancy.
I'm going to ask the first question here. When you talk about timeliness of decisions, I think it's fair to say that some take longer than others. But at the same time, you want to do all this outreach. You want us to go all over, which we do a lot now. I think you're aware of that.
Yes.
When I was your liaison judge, I think I was down there almost once a month, besides going to other parts of the state. How do you balance the adjudicative work with the other things you want us to do and still come up to be more timely? Especially, I don't know if you're aware of, we only have 6.5 law clerks for 7 justices. We are probably, from a numbers standpoint, and I just saw it in a law review article, we're the 14th or 15th or maybe 13th most productive court in the country. Most Supreme Courts do less than 100 cases a year. So you want to do all this, and you want to get the cases more timely. I mean, where's the time to do all this? And what would you model? What state would you model it after, where they have these things?
I'll try to answer the question in parts, and if I miss a part, please let me know. With regard to the importance of timeliness rules, I know from experience where we district court judges are subject to the 60-day rule, that even when you totally keep up, it's on your mind that there's a goal. It's something that you calendar when you take a case under submission, and so you're thinking about it. And it helps you set priorities in terms of which case comes first in what pile. And maybe the most important thing it does is that in the situation where you have a case that exceeds your guideline, you explain to people what the reason is, so that you can broach understanding that wouldn't occur otherwise. And so the existence of a rule is a good tool for people. And I think from a political standpoint within the branch, it would be a very positive step for all of our courts to be subject to a timeliness standards. With regard to your question about how you balance the adjudicative responsibilities and the administrative responsibilities, it's just that, it's a balance. Adjudication is crucial because the Supreme Court is considering cases of first impression, and they're hard ones, and they require a lot of deliberation and collaborative discussions of all of the justices and great research and great writing to communicate that result and why it's the right result, and make it in a format that's usable by jurists and lawyers and the public for years into decades, maybe centuries. So that's very important, but I know from my work in adjudicating many, many cases at the trial level that great adjudication falls flat if it's not administered well, if it's not delivered well. And so the administrative responsibilities that the court has are so important and have to be worked in.
Can I interrupt you for a second? I'm sorry,
Surely.
but I don't want to take everybody's time. But one of the beauties of our Iowa Supreme Court is that we don't require justices to be in Des Moines. We're one of the few states in the country that don't require them to live in the place where the capital is or have a term that defines when things have to be done or not done. And, you know, if you get a case done and you're not, and the other justices aren't showing up for another 3 weeks or 4 weeks, and then someone has a problem with it, and they're not showing up another 3 or 4 weeks again to go over it, would you go as far as saying if your time limits are so important, would you require justices to be in Des Moines so they can work through those problems and not, you know, head out after they have their meetings back to their separate towns and villages?
Well, I don't see the timeliness of the work to be directly linked to face time in Des Moines. Now, I think that face time in Des Moines is crucial for some of these outreach initiatives that I've talked about. For instance, building new and better relationships with other branches of government requires us to be where other branches of government are, where their people are. And that's often in Des Moines, and it's often out in the state elsewhere too. So I don't link timeliness and residence.
How do you adjudicate without being together?
But
And a collective decision. I know you only decide it yourself.
That's right.
But when you write something, it's a decision of 7 people or maybe 4, not 1.
Yes. And I think there would be a number of instances for us to draw some guidance and maybe come up with a new work style for the entire court. Technology is a great tool, and courts like the Court of Appeals very effectively use email technology to share ideas and to share drafts. Skype is a great technology if you have a person that can't make it in for a conference, or I think there are ways to set up Skype programming with a number of people. Even though I'm a sole decision maker in my trial work, I have done numerous things that are very collaborative in nature and do many of those things by email and using other people skills. For example, the work that I've done with the American Bar Association and the National Trial Judges Group involves email work all the time, and we accomplish very substantive things doing that. And so it's something that the court as a deliberative body needs to come to grips with, and I'm confident that all of the intelligent, motivated people there sitting down, putting their heads together, could come up with some ways to improve efficiencies and to spot where those are. And I'm not in a spot to say where those might be or might not be, but I think it would do a lot for the morale of the judicial branch for us to have some time guidelines in place. And I think it would help the court focus on timeliness, because it helps me focus on timeliness to have the 60-day rule. And I'm just confident that there are ways that we can come together on to improve our service.
Any questions, Mr. Pace?
Oh, thank you, Justice Wiggins. Hi, Judge. You said, I think I wrote this down correctly, courts protect the rule of law, and the rule of law protects the people. If I got that sort of right.
I did say that, yes.
Okay. How does that work? How does the rule of law protect the people? And does public opinion of what the law ought to be come into play there anywhere?
Well, you know, the magic of the rule of law is that it's consistent, it's predictable, it applies to everybody, and that gives us stability in our country. That probably to a term is the thing that has allowed our form of government to have the enduring success that it has. And the courts, in applying the law and doing that conscientiously and consistently and over time, make that rule of law a predictable framework for our society to operate in. The rule of law protects the people because the very essence of it is that the same law applies to everybody. The stop sign out at the intersection applies to Annette Scieszinski driving up to it. It applies to Steve Pace driving up to it. It applies to Barack Obama if he happened to drive up to it. And that makes us all have rights that are protected and consistently revered. And so we as the court system are applying the rule of law. We're making it real every day, and the public should take great confidence in that as part of the message that we have to get out there.
Ms. Dixon, you had a question?
Yes, Judge. I just wanted to take you back quickly to the issue of geography. In terms of, you're in Albia, correct?
Yes, Monroe County.
And there's different theories on this, but I'm from Eastern Iowa, obviously, and I've received a lot of feedback regarding the issue of geography. If you could just address that issue in terms of how it might be beneficial or how it could be important to consider a variety of geography in terms of the decisions that we make.
I know that that's an issue that is a hot one with many people, and I think that issue, like other diversification types of issues, gender and so forth, is really something that doesn't enter into the merit stage of this process. Whether people live in Des Moines or whether they live somewhere else, how much work they get done and how efficiently they do that and how collaborative they are with their colleagues, I believe, turns more on that person's professional makeup and drive than it does on where he or she lives. A person that might live at the furthest point away from Des Moines might be the most fabulous justice ever, because they do what it takes to keep the lines of communication open with other justices and to work hard and get their things done on time and to move the dynamic of the court. And somebody who lives 10 minutes from the courthouse might not exercise those kinds of initiatives and that kind of energy, and might not be able to accomplish all those things. So I think it really turns on the individual and the approach the individual takes to the responsibility. And similarly, with issues such as gender diversity, same thing. You know, one of the great pieces of experience that you have being a jurist and having worked with all kinds of other jurists is, you know, that they come in a cross-section, just like plumbers, just like electricians, just like farmers, and you have folks that use all kinds of different styles and have different priorities. And so what you're looking for here is a mix of priorities that you think are going to work, and that should not turn on gender, and it should not turn on your zip code and any other factors that you might come up with. Now, having said that, here at this merit stage, it shouldn't turn on those factors. But those are very important factors to the people. And the people want to be heard, and they want to feel like the folks on the Supreme Court have a broad view of things and understand what it's like to deliver justice in each corner of the state. And justices need to have a feel for how it is to deliver everywhere. I think it's a political decision after the merit work is done. And I think it's perfectly appropriate for a governor, for example, making that political decision after the merit decision's made here to decide what the people need.
Is there anybody on this side of a question? Mr. Holm?
Thank you, Justice Wiggins. I wanted to, I'll make it very brief, but I wanted to pay you a compliment as a preface to my question, because in reviewing your materials, it's obvious that despite a busy schedule as a judge, you have devoted a lot of time to public outreach. I took a look at your 2010 schedule, and I counted 8 separate incidents where you were out in the public talking to people, a senior center, a high school class, a college class. And I'd be interested in your observations on how that type of outreach that you've engaged in has impacted the people that you've interacted with. What kind of impact have you seen on the people that you've spoken to or that you've interacted with in these public sessions? What effect has that had on them?
It's tough to know what the long-term impact is, and you have to assume that it has long-term impact. And certainly it builds rapport with the people. What I often talk about, whether the speech is titled this or not, is I talk about the rule of law and how it impacts those people today and how it's going to impact them tomorrow and into the future, so that they have a feel for the living nature of the work of the courts and their stake in it and their role in it. We talk about jury service, and we talk about the reliability of the court system to do the right thing if ever you need relief on a matter that comes before the courts. So I look upon it like it's an investment, but I haven't figured out yet how to measure the return on that investment. I'm confident it's there.
Any other quick questions? Well, Judge Scieszinski, thank you very much for spending your afternoon with us here, and we wish you the best of luck.
Yes, thank you for your consideration.